You're being questioned by the defense lawyer in a medical malpractice case. You're sitting in your attorney's conference room, and now you're sitting there quietly waiting for the next question when all of a sudden the attorneys start brawling. Not physically, but verbally. They are yelling and screaming at each other. What do you, as the litigant, as the person who has brought this lawsuit, what do you do when this happens? You want to know the answer? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is you do nothing. You sit there and you wait until the attorneys are done arguing. It might get heated. It might get loud. It might be aggravating. You're going to feel the tension in the room between the attorneys arguing. Now you might be thinking, wait a second, this isn't trial. This is a pre-trial question and answer session that's being done in your attorney's office. This is supposed to be a professional proceeding. There shouldn't be all this screaming and yelling. Your attorney didn't tell you about this. Your attorney didn't tell you that there was the possibility that there could be mad outbursts and yelling and screaming and table pounding. Now, first of all, why would that ever happen? I'll tell you why it could happen. It could happen because the defense attorney asks a question which your lawyer feels is totally inappropriate. And now your attorney is fed up. Your attorney is upset. Your attorney yells out, "Objection! I direct the witness, I direct you, my client, not to answer the question." And now the defense attorney starts arguing with your lawyer. And they're arguing, they're having a legal argument about whether or not the question and the topic is appropriate. And now you're just sitting there. You're waiting for an instruction, you're waiting for some signal from your attorney about whether or not you should or could answer the question. And now this is going on for a few minutes, at which point somebody says, "You're being obstructive." "No, you are." And now it sounds like they're acting like children. It sounds like they're acting like children having a disagreement, having a dispute. Finally, one of them stands up and says, "I'm calling the court." And the other one says, "Go right ahead, but I'm not participating in that phone call." And you're listening and you don't understand what's going on. What's going on is that one attorney is fed up and now he needs the court to intervene. He needs to call the judge to get a ruling on whether what this question involves is appropriate. Now, your lawyer turns around and says, "Wait a second, I am not going to participate in that phone conference." Now, what does that mean? It means it shuts down any attempt to call the court. Now, why is that? Because when the attorneys call the court, they have to do so together. The judge is not permitted to talk to one attorney alone. That would be known as an ex parte communication, where one side is having a private conversation with the judge, telling him something. It may be a joke, it may be something unrelated to the issues in the case. But because both sides are not there listening or participating in this conversation, the judge is not permitted to have that conversation, unless, of course, it's a settlement conversation where he specifically wants to talk to each side individually and separately. But this, in the middle of a deposition, in the middle of this question and answer session that takes place during the course of your lawsuit, this is not what we're talking about. So now you're sitting there and you don't know what to do. The answer is you sit there and wait. You sit there quietly and patiently and let the attorneys argue amongst themselves. It's not going to be pleasant. It's not going to be appropriate, but you should know something else. This really should not be happening, and I'll tell you why. The courts have created a rule that says attorneys are supposed to conduct themselves in a professional manner. If one attorney has a problem, call the court. It's that simple. If one attorney has a problem or one is being totally obstructive and now not allowing a witness to answer or creating problems for the other attorney or being nasty or condescending or whatever it is, now the offended attorney has the ability to put that information on the record because there is a court stenographer there who is there to record all of the questions you are being asked and all of the answers that you give. And this whole argument that's going on should be recorded by the court stenographer so that now there's a permanent record of exactly what went on. And what the offended attorney will do after your deposition is done is wait for that transcript to come back of everything that the court reporter has recorded, and then ask the judge in a written format, in a written fashion, to intervene and say, "Judge, I was questioning this witness, Mr. Oginski's client, and during the course of deposition, I asked the following questions, and Mr. Oginski refused to allow his client to answer these questions. He obstructed repeatedly, as you can see by this transcript in pages 22 through 35. And that prevented me from asking key questions to help our defense in this particular case. And then the attorney would have to substantiate and to support his legal argument. Now, when the attorney sends those papers to the court, I would then have an opportunity to respond. And I would let the court know exactly why I believed it was inappropriate for my client to go ahead and answer these questions. But I will tell you, one of the key reasons why the court system actually created rules to make this a more civil process was because in years past, this is exactly what would happen. The attorneys would have a free-for-all. They'd be brawling, not physically, but verbally. And it would be so uncomfortable for the clients, it would be so uncomfortable for the litigants, uncomfortable for the court reporter, that now sometimes it became very personal. And now one attorney is accusing the other of doing something wrong, and now somebody else calls the other one names, and now it just escalates and devolves into nonsense. And that requires a court to intervene. So let's get back to the title of the question that I raised in the video. What do you, as the party being questioned, do in that instance where the attorneys are now fighting, where the attorneys are arguing, where they are brawling? The answer is, you do nothing. You sit and wait until the attorneys have resolved their differences, and even if they can't resolve their differences, in all likelihood, they will move on to the next series of questions. And yes, you may have to take a breather. Yes, you may have to calm down. Your attorney may have to calm down. In which case, that's fine. You take a few minutes, everybody calms down, gets a little bit of air, and now you start questioning again. So why do I share this information with you? I share it with you because nobody shares this great information with you. Think, okay, if I'm injured, I can just go hire an attorney. The attorney will go ahead and start a lawsuit, and we're off to the races. No, that's not how it works. This is part of the process, part of the litigation process, to help you understand how these types of cases work. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you do have questions and your matter happened in New York, but you have not yet started a lawsuit and still have questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.